This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. How does a defense attorney overcome a jury skepticism in presenting a case involving the insanity plea? Today, we're going to look at this issue and find out when an attorney will use the insanity defense, as well as look at some other notable cases where it was used. Our guests are Barry Slotnick, a well-known criminal defense attorney, and Dr. Stephen Simmering, a forensic psychiatrist whose case list includes former Judge Saul Wackler, the Exxon murder case, and the List case. Hello, Barry. Hello, Dr. Simmering.
Good to be here.
Okay. Barry, Bernard Goetz is much in the news today. Now,
unfortunately.
Okay, you represented Bernard about a decade ago, very successfully, I may add, when he was acquitted of shooting, I guess, the very person who today he lost $43 million to.
Right. In fact, he's not writing a check, so I wouldn't worry about that too much.
Well, I just recently read he had to go bankrupt because of the lawsuit.
Absolutely. I mean, the travesty or the tragedy of what happened in Bronx County versus what happened at the criminal trial that I had tried is enormous. It sends a message out to the community that's a very wrong message. What really happened, the inside story of why this trial went this way, is that basically Bernie, at this stage in his life, has no funds. If you remember the case that I tried, we had experts, investigators, we located witnesses, and we had lots of money to be able to spend so that we could find the appropriate witnesses. In the new case, it took 2 weeks to try. My case took over 2 months. In the new case, there wasn't one witness who was on that subway car other than Bernie Goetz. One witness wasn't located to say, I saw him surrounded. I saw that he did what he did. I realized that they got what they deserved. All this jury saw was a videotape statement, frivolous Bernie Goetz on the witness stand because he just was silly, and came back with a conclusion. And the New York Times editorial, the Daily News, the New York Post, every major newspaper in this country said, well, that jury awarded the money because of the second shot at Darrell Cavey. Darrell Cavey was shot once, not twice. And when I read a New York Times editorial, which vindicates what the jury did, talking about the second shot, they accepted what that jury accepted. The plaintiff, Darrell Cavey's lawyer, was able to convince the jurors and everybody else that Bernie fired at Darrell Cavey and hit him twice. Not true, never happened.
But it's been reported in many of the newspapers that they feel the verdict of $43 million was because now the tenor of our times is different than it was a decade ago. And had you tried the same case with the now mores of our times, you would have lost it. How do you feel about that?
Oh, I don't agree at all. I think if I would have tried the same case in Bronx County with that same jury, with the same defense, with the same witnesses, with the same people who viewed the scene, Bernie would have had a verdict for him. I think it's got nothing to do with the mores of the times. I think it has to do with what the jury didn't see.
Dr. Simmering, you're a psychiatrist, a very well-known psychiatrist. Now, this personal persona that Bernie Goetz has, tell us a little about how Bernie Goetz perceives himself, if you can.
Well, he's I know about him what I read in the paper. You've met him at first hand. He comes across like a kind of a creep. But in some way, he comes across as everyman, because we live in a time now where people are kind of paranoid. Even though crime's down, and even though crime's not on everybody's front pages, there's probably more resentment out there. There are a lot of Bernie Goetz fans, the jury verdict notwithstanding. Bernie Goetz The 43 million, it could have been 43 billion. That doesn't mean anything. What happened with Bernie Goetz is he's getting job offers now. I understand he's going up to Boston to become some kind of a consultant. Bernie Goetz is going to be wealthier as a result of this, whether or not they garnish 10% of his salary.
Well, you know, I don't think that what occurred is when you say Bernie Goetz has fans, yeah, he does, and he has a constituency, and maybe that's sad. But what everybody overlooks, because they say, well, this is now a racial issue. It never was a racial issue. It wasn't a racial issue the first day. It wasn't a racial issue at the time of the shooting. It's not now a racial issue. What occurred was a very simple factor. After the $43 million verdict came out, they polled the people in the housing project where KB lived. And those people said, a great majority of them, this was terrible. He didn't deserve to get that money. We know what he was about. At that trial, I characterized him as a thug who was out on a mugging. That what Bernie Goetz did was absolutely justified.
Well, I'm not sure it doesn't have racial overtones, because I remember even during your brilliant defense, many black people saw it as a racial issue and some white people. What I'm surprised is you handled a brilliant defense for Bernie Goetz, and you got the proper verdict. On the other hand, in the civil case, the case was thrown. The attorney for Bernie Goetz threw the case. He was completely and utterly incompetent. The attorney for KB is a very able and very competent lawyer. The case was thrown. Why should, from the jury selection right on down, the case was thrown? Why should any jury being given this not come out with a verdict?
Well, I'm saying what the jury saw in that courtroom was appropriate.
So they did the right thing.
They did the right thing in that courtroom with what they saw.
We have some
Absolutely.
system of justice. I mean, if the jury shouldn't be going to the housing project and find out what they think of Darrell KB. The jury did the right thing based on what it saw. And what it saw is a totally incompetent lawyer who, for whatever reason, didn't even care about this case because he probably knew it didn't mean anything, against a very highly competent lawyer.
What the jury didn't see is what really counts. They didn't see what the first jury saw. They didn't see the tragedy, the trauma, the other individuals. They didn't hear the evidence of those that viewed Bernie on the train.
But in some ways,
that's terrible.
In some ways, it's the opposite of O.J. Because in O.J., there was an acquittal, and now some people hope that the civil jury are going to see things that the criminal jury never saw. But we all know who work in the system that what counts is before the jury. I mean, if you're going to say, I don't think anybody watching that case would think, regardless of the merits of the case, that any jury would have brought in a verdict for Bernie Goetz, given the case that was presented there.
No, given that case, no. Someone asked me today, if you tried your original case, your question, in the Bronx before that jury, and I saw that jury, I came in to watch the summations, what would the verdict have been? They would have given Darrell KB.
Oh, well, on the other hand, you can't try the original case because it's a criminal case. In your case, your client did not have to testify. In your case, he would have had to be convicted by a unanimous jury. That's not a civil case. The rules are different. The venue is different. It's very different. What I would have liked to see, I would have liked to see you come up against Ron Kuby.
Did Bernie Goetz testify in the first case?
No, he did not.
There you go.
But I had a videotape statement of his in which he said, I shot them in the back running away, all those terrible things.
But that was under your control, and you had a videotape and you properly used it. What if you had tried this case and Bernie Goetz had testified for you, with all the preparation, the way he testified here?
I don't think he would have testified that way here. I think
You
that
can control witnesses?
No, I think that Bernie Goetz would have stated, simply understated and properly stated what he really meant.
You would have plugged him in and put a tape. How would you control Bernie Goetz?
It's a very simple proposition. Bernie,
Bernie.
you don't really mean that you think Mrs. KB should have had an abortion.
He does think it.
Okay, fine.
He does think it. He does think it.
All right. Mr. Goetz, do you think that Darrell KB's mother should have had an abortion? Objection sustained. Irrelevant to the issue. His feeling about whether Darrell KB should have been born or not has absolutely nothing to do with what happened on that train.
Depends on the judge's ruling.
Dr. Simmering made a very interesting point. He said, well, now many people are waiting in the civil case on O.J. Simpson to see what the jury does on that. If you had a crystal ball, if there was this huge crystal ball on the table, what do you think is going to happen in this civil case on O.J. Simpson?
I think the jury is going to dwarf the Goetz Award and make a bigger award for the...
You mean multi-millions of dollars?
Absolutely, absolutely.
And he has money.
Today. We don't know what he'll have by the time this case goes to trial.
There'll be
Doctor,
nothing left by the time he goes to
Doctor,
trial.
answer me something. Now, O.J. Simpson, here he's just gotten off from being accused of brutally murdering his former wife and a person who happened to be there. And yet he goes, he's taking a public persona. He's on TV. He wrote a book. He's got a videotape. He's playing golf. He's into the media. I mean, how do you perceive the personality as opposed to being low-keyed that is doing all this?
Well, I think the whole thing is really a big mistake for him to, and he's been clobbered every time he's come out of this thing. He would have been much better off to lie low for a while and cool out. I've never spoken to him. I don't know if this behavior is a kind of manic rebound from being in jail. I don't know if it's a desperate need to be loved. I don't know what it is. All I know is it's backfiring like crazy.
What do you mean, a desperate need to be loved?
Well, he's Mr. Love Guy. This isn't Bernie Getz. I mean, Bernie Getz is the guy you love to hate. I mean, he's got his screwballs who not. I mean, he's got his constituents out there, but that's not his persona.
Barry Slotnick may not be one of them. I don't want you to indicate that he
I have
is.
the papers for defamation.
O.J. Simpson's a guy who loves to be loved. He is a guy who genuinely likes being loved. Also,
remember where he came from. The milieu that he came from, he was O.J. Simpson, the star.
Sure.
You know, stars, when their lights go out, are very unhappy.
That's
and you
absolutely
deal with these
true.
people all the time.
All the time. Yeah. And, you know, it surprises me. I mean, thank goodness, I hope we don't talk about O.J. It's been talked about enough. But I think that everybody's got their opinions about that case. Yet I think that just looking at what the jury saw and the way that case was tried and all the evidence that came out, I think that's what the jury had to do. Everybody is speculating about what should have been done and who they should have talked to and what they should have seen. I've got faith in the jury system.
Yeah, so do I. I think that the O.J. verdict was a result of over-prosecution.
Absolutely.
I mean,
And
I
a weak
think that-
weak judge.
Well,
I may point
horrendously
out
weak
on this
judge.
very show, Barry, you had said, and you were probably one of the only one that said he would be innocent months before.
I didn't say he would be innocent, he would be acquitted. There's a great difference between the two.
I think that point is absolutely profound. It was a case of over-trying and over-prosecution. It was taking
Okay.
a simple case and turning it into a nightmare.
Let's talk about, you know, like we just had the O'Leary, who was convicted of doing a terrible thing, this firebomb on the subway, and Ira London's attorney had a defense of temporary insanity. I mean, what is temporary insanity?
No such thing. Most states don't recognize any such thing as temporary insanity. What states recognize is a mental condition such that, generally speaking, you don't understand the nature and quality of your act, or you don't know what you're doing is wrong. There are a few jurisdictions that formulate it in slightly different ways. Someone can have a genuine mental condition so that his perception of reality is so distorted that when he shoots somebody, he thinks he's waving hello. If that can be proved, that's insanity. If it lasts a short time, I suppose that's temporary.
Well, that's an easy one, that I don't know what I'm really doing.
Right.
Or it's not wrong.
Or it's not.
Essentially, we have a good insanity defense when someone goes out and shoots somebody and they don't run away. They put the gun down, they go sit down, they walk to the corner, they have a
And I've heard
sandwich.
about those things.
Right. Those are, you know, classic events that show to a jury, well, this person apparently had a problem, a mental disability, didn't know the nature and consequences of his act, didn't know whether he or she was doing something wrong.
And the classic, when wrong means wrong according to the law. Now, if you believe that you have a right to go out and shoot Yugoslavians because you're whatever group you're, that doesn't count. What the inability to understand wrong means that you literally don't know that what you're what you're doing is wrong. You see a stranger come up, you think that stranger is out to kill you, and you act in self-defense.
Well, what about the example of the gentleman who works in the post office, who all of it has a wonderful work record, works every day, never misses a day's work in 10, 15 years. One day he takes a gun and he shoots 6 people and he goes back to work.
Remember there was a movie once, I think it was called Network or some movie, where everybody's hanging out the windows saying, we've had enough, we're not going to take it anymore. You've got to separate frustration from genuine insanity. Lots of crimes are committed by people who are mad, damn mad, but mad in the sense of being angry. Their wife's cheated on them. Their boss has given them a bad deal. They've been fired. The system's dumped them. They're under stress. That is not insanity.
Well, your post office official who went back to work after shooting 6 people, I think that he would probably have a fairly decent insanity defense, because what we could say to the jury is, if he knew what he was doing was wrong, or the nature and quality of his act, he would have run away. He would have gone to Iowa and hidden. But yet, in clear daylight, he then went back to work. So that's one indicia. What we do as lawyers is first we consult with the doctors, and we see what the forensic psychologists and psychiatrists have to say, and then we put it together to see whether in fact we can tell it to the jury.
We have to take a break now, but right after that you'll tell us on what cases you use the insanity when it's successful. You're watching Lawline. Stay with us. Hello, I'm Alan Schnorman, the host of Lawline, and I want to give you some important information about your legal rights. If you were seriously injured in an automobile, a fall down, or construction accident, you may be entitled to a substantial money award for your pain and suffering. It is important to speak to a knowledgeable attorney in that field. At my firm, Solomon & Schnorman, our practice is limited to personal injury law. We fight for the rights of accident victims. Don't try to evaluate the case yourself. If you have any questions about your accident, call us at 1-800-LAWLINE. If you're too injured to come to our office, we will come to you. The consultation is free, and we only get paid when your case is settled or won. Remember, the insurance companies have lawyers protecting their interests, and so should you. Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about the insanity defense. We're honored to have Barry Slotnick, a noted criminal attorney, and Dr. Stephen Siemering, a noted forensic psychiatrist. Barry, let me ask you this. Now, on the Bernard Goetz case, did you use a psychiatrist?
Not for court, not for presentation. We used a psychiatrist for a very limited issue, almost as a technician, to testify to the jury what happens when someone is confronted and they pull a trigger. It's called automatic pilot. We did not we didn't put in a psychiatric defense because I didn't want Bernie, 1, examined, and 2, to put his inner psyche on trial.
Were you scared that he possibly had a nut that wasn't solidified?
Well, that would be inappropriate for me to say. Let's just say that I didn't wish to put Bernie's present state of mind on trial. And so therefore we didn't use a psychiatrist. People said it was a perfect insanity defense. Why didn't you say it? He snapped, in his own words, I snapped. And I said, we don't need a psychiatric defense. We've got self-defense, and it works because it's real and it's the truth.
Mr. Slotnick's view is a very sophisticated one. A lot of defense lawyers take a psychiatric defense as an easy way out, and they end up hoisting themselves up on their own petard, because you usually can't have it both ways. If you have a psychiatric defense, you have to say, my client did it, he committed the crime, he did all these things, but he is so out of touch with reality that you have to understand. Remember, in OJ, there were no psychiatrists because they maintained innocence. Had they brought in psychiatrists, they would have had to start tinkering around with questions of guilt. In cases where the individual is so obviously mentally ill that lay people can see it, these cases don't even go to trial. A couple of psychiatrists get involved, there's agreement. In contested cases with insanity defenses that go to trial, practically none of them ever sell with the jury. John Hinckley, the man who shot President Reagan now 16 years ago, was the great exception. What happens is, nowadays, in my opinion, is that insanity defenses are often put in when there are no other defenses, and if they're used skillfully, it gives the jury an opportunity to do jury nullification, if you will, to use some common sense and to reduce the charges.
Doctor, what about Colin Ferguson when he boards a Long Island railroad car, pulls out a gun, shoots a number of people, and then all of a sudden tries the case and says someone came down, presented themselves in the car, and then went right back up? How could he be not crazy.
Well, we seem to be, we've talked about Colin Ferguson before. The problem with Colin Ferguson is it was much more profound than that. Colin Ferguson, I don't believe, was even competent to be tried. Or if he was competent to be tried, he certainly was not competent to act as his own defense attorney. There was such a fundamental violation of fairness to put on that circus of Colin Ferguson acting as his own attorney that the thing was poisoned from that point on. Even if it had been done right, Colin Ferguson's crime had no sympathy. This isn't a racial issue or anything. Nobody would sympathize with that.
So he was convicted because of anger.
Right. If Colin Ferguson or if somebody had done a crime where a sizable segment of the community could have been sympathetic, like Bernie Goetz, however you see it, they could use an insanity defense to mitigate, not the sentence, but mitigate the verdict with which they were going to come down. It gives the jury an excuse.
You know,
They're not supposed to do it that way, but they do it.
The case that shocked me, you talk about Colin Ferguson, that serial killer, Joel, he killed 17 prostitutes, Joel Rifkin.
Yes.
That surprised me. I mean, he was convicted, and I thought that Joel Rifkin would be acquitted on the grounds of insanity, but yet a jury heard the whole thing. This man who killed 17 women.
Give you a better
sorts of
example.
strange things.
Jeffrey Dahmer.
Absolutely.
He killed him and ate him.
Right.
And the jury convicted him nonetheless. I challenge you to name a high visibility case other than John Hinckley.
Doesn't happen.
A contested case where it happened. It never happens. Juries don't buy the insanity defense, but what they do is, because now we have mandatory sentencing, we have tough guidelines, we have high maximum sentences, that it is giving the jury a not appropriate, I mean, it's not what it's supposed to do, but it's giving the jury a way out.
You see, there's a book, by the way, that was written by Alan Dershowitz called The Abuse of Excuse,
yeah.
in which he derogates, denigrates, talks down about all the defenses we put forward. And in discussing this with him, I said, Alan, most insanity cases fall. Juries find these people guilty. Why are you so upset about it?
That's right. Look at Menendez. Even though temporarily they came up with some fancy theory of child abuse and all that, that was a case that just got out of hand. When it was retried in a simple, direct manner, the jury rejected it out of hand.
But you were retained on Judge Saul Wackler. Now, you were retained by the government to examine him, and you did examine him.
Yes.
Yet nowhere did I see an insanity defense from Judge Wackler.
Well, after the expert reports were prepared, my report and the very eminent doctors who examined Judge Wackler on his behalf, the lawyers made the strategic decision to accept a plea. So there was no trial.
They didn't want to face you in court.
Now, it was reported that you stated in the New York Times that he was lovesick. What does that mean?
Well, I don't want to talk about this case other than what's in the public record. Okay. It was stated in one of the news media that my report came to that conclusion. And what that meant is this. Psychiatrists have a tendency to label every human condition with a psychiatric diagnosis. And I could have scanned the book and found some psychiatric diagnosis that fit. I was trying to make the point that there are serious human conditions which can lead to serious crimes which are motivated by issues in human life, not mental illness. For example, anyone who's ever been divorced knows just how nutty you get during the divorce period of time. Anyone who's ever been jilted by a girlfriend or boyfriend whom they love. Everyone who's ever been victimized by a crime. People get angry, people lose their temper, people have stress, people have midlife reactions. These are not psychiatric defenses, and these are not illnesses. And I was trying to make that point.
So that's not insanity. When you get so mad that somebody says something, or that you find your spouse in bed with someone else,
right,
and you pull out a gun and you don't know what you're doing, you grab the gun of the person who is in bed with your wife and you shoot both of them. That's...
Well, it could be.
I'm an accountant. I've never even handled a gun before.
Saul Wackler was not the first and will not be the last man who was charged with committing a crime in the heat of passion after losing a lover or after losing a girlfriend. People act very crazy. The only thing that made that case unusual is we have the idea that if we're very smart and we understand things and we're very sophisticated, we don't have emotions. Everybody has emotions, but you can't mix up emotions with insanity.
But going back to that accountant who took the gun right from the bedroom table and shot them both, is that Barry, would that be something that you would possibly try to put down an insanity defense for?
I had that case. It wasn't an accountant. It was a television executive. And the jury accepted the fact that during that period of time, this person had a mental disability and didn't understand what the consequences of his act were, and acquitted him on the grounds of insanity.
Now,
What do you think of that?
I think it's again a tribute to your skill.
No, I think it was real. I mean, I really think we tend to mix up insanity with crazy. We shouldn't do that. There's a legal definition of insanity. And the legal definition of insanity, you've stated what we know as the old McNaughton rule, or modifications of it. The
Which
jury
still exists in most jurisdictions.
in New York, we have a modified form of it. In fact, I would have a burden. If I went forward in an insanity defense, I would have to prove certain elements of it by a preponderance of the evidence. The important issue is when you see somebody who's walking around and they're talking to themselves and they're doing strange things, that is not insanity. Under the law, it may be insanity in your massive book that you carry and read.
No,
and
insanity is a
diagnose
legal
from.
term. It might be schizophrenia, it might be psychosis. Insanity is a legal term.
Absolutely.
And it depends on the standard. And what you say is
And
absolutely...
psychotics are criminally liable unless
Of course.
they meet the insanity
I had a case
defense.
a long time ago of an individual who was diagnosed with schizophrenia, a severe mental disease. He heard the voice of God. He escaped from a mental hospital, and then he went out to rob a bank because he needed money to support himself. He was psychotic, he was schizophrenic, but as far as the bank robbery was concerned, he knew perfectly well what he was doing, and he knew what he was doing was wrong, and he had a reason for doing it. Incidentally, this standard that we make such a fuss about, the McNaughton standard, the strict standard, more liberal standards like the ALI standard, studies have been done to show that it doesn't mean a hill of beans. We all learn in medical school and law school that that's very important. What is important is what makes common sense to the jury.
Jury's perception.
Right, jury's perception.
All the
If
time.
the jury looks at a guy and says, this guy looks normal, he acts normal, I don't understand all this fancy garbage, the jury is likely to reject the insanity defense.
On the way over, I spoke to my wife on the car phone. What are you doing? I said, well, there's a little insanity defense. She said, well, I hope you're going to say that it's abused. I said, I'm not going to say that. It's a defense that everybody has a right to if they meet the profile. And if they're not legally insane, juries say guilty.
Barry, what about this case in Delaware? We have a man who is heir to a huge fortune, has tens of millions of dollars, and all of a sudden kills one of the Olympic stars training on his property, who he nurtured.
I can figure out a number of defenses. One, self-defense. Perhaps he was fearful of his life. Two, perhaps there was an insanity defense there. We don't know enough of the facts
right.
of what occurred during the course of that event, that short little event. Once we find that out, we can then sort out and say, is this defensible? Is it not? Does it come within it, not responsible for my act?
And there's a third major issue that comes up, namely, were drugs used? There was cocaine at the scene. That changes the whole ballgame.
Absolutely.
You heard it here. Let's see what the newspapers report. Dr. Stephen Simmering, thank you again for being on Lawline. Barry
Take
Slotnick,
care
once more,
again.
thank you for being on Lawline. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.